I'm the president of the Western Canada Commercial Arbitration Society, and I'm an independent arbitrator and mediator in Calgary. We have a topic this morning that I hope you're going to find to be of interest. It was set out in the program materials, and we call it Speed Up Your Litigation, the Role of Arbitrators in Case Management and Other Pretrial Proceedings. And the genesis for this is the court system has become increasingly ineffective in resolving commercial disputes. The delays are making the procedural steps are unacceptable. Our view is that case management of complex litigation can improve efficiencies and access to justice. I know in Alberta, in my jurisdiction, case management by judges is effectively no longer available. Arbitrators can play an important role in this system in pretrial proceedings for parties whose disputes are in the court system. They can act as case managers to move cases along. They can hear contested pretrial applications. And this panel will explore the roles that arbitrators can play in the court system and how their decisions will become enforceable. We have 4 members on our panel, and I'll start by introducing to my immediate left, Jack Marshall, KC. Jack practiced commercial litigation and arbitration for 45 years with Kyle Dixon in Calgary, which then later became Norton Rose. In 2012, he left the firm and set up practice as an independent arbitrator and mediator. He has conducted arbitrations in 7 Canadian provinces and internationally. He was a founder of what is now ADRIC and also a founder of the Western Canada Commercial Arbitration Society. He's a colleague of mine at Western Arbitration Chambers in Calgary. To Jack's left is the Honorable Christine Isaac, KC. Christine has been involved in dispute resolution for over 40 years in Alberta, both as counsel and as a judge. She served on what is now the Court of King's Bench of Alberta for 15 years. She resigned from the court 2 years ago and is currently conducting an independent arbitration and mediation practice, once again at Western Arbitration Chambers in Calgary. And to Chris's left is Rob Dean. Rob is with Borden Ladner Germain in Vancouver. He's recognized nationally and internationally as a leading counsel in commercial litigation and arbitration. As arbitration counsel, Rob has appeared in significant arbitration proceedings in North America, in Asia, and in Europe. And as an arbitrator, he's chaired or been a sole arbitrator in international and domestic proceedings involving parties throughout the world. We, like the last panel, would like to have this to be informal, and we invite questions from you. We'll be doing this with a series of questions that I'll place to initially one member of the panel, but invite all members to speak to it if they wish. And then, of course, invite questions from the audience. We have some experience in this area, but more it was driven out of a matter of interest and a matter of concern about the ineffectiveness of the court system. I know in my jurisdiction, but I believe through most provinces in Canada. We also know, though, that there are others in the room, and Megan, I'm looking at you, who have considerable experience acting as a case management arbitrator and have views on the topic, and we invite them to share those views with all of us during the course of the presentation, or if we have time at the end. The problems with delays, as I understand them, are effectively common throughout the country, but the solutions might vary depending on the culture of the bar, the attitude of the judiciary, and the rules of court. There may be some opportunities in some provinces that don't present themselves in others. So with that introduction, what I'd like to do is start with the first question, and that's to address in more depth than I have in my initial comments. What are the problems in the court system that arbitration can address? First, I'll turn to Rob to speak to BC and Ontario, I believe, Rob.
Well, thanks, Dan. And I know this is a hot topic, and the proof of that is that John Campion posted an article on LinkedIn an hour ago. So what better validation for relevance on the panel is that? So Dan, every jurisdiction in Canada, to one extent or another, is really breaking under the stress of doing too much with too little. There's too few judges. I see that some progress, I've heard some progress has been made in that regard, but I haven't seen the results on the ground yet. There's too little hearing time, too few registry staff, just too many cases. And the stories are familiar. It can take months or even a year in some locations in Ontario, I understand, to have a simple interlocutory application even heard. In BC, and while this is supposed to be changing later this year, we have a telethon on the first Tuesday of every month, a literal telethon. That's when the dates for applications of more than 2 hours become available for a month that is 2 months in the future. And firms literally organize teams of assistants and lawyers to inundate the court registry staff with phone calls, trying to get a date. It's like buying concert tickets in the last century. It's a statistical fact, though, that you are more likely to fail in that calling derby than you will succeed. And even when you do get a date, it's very likely that there will be no judge available to hear the matter several months hence when you show up. My rule of thumb is that for a matter of any complexity that is half a day or a day, certainly, you typically have to expect that you're going to be bounced at least once, probably 2 times, before you elicit sufficient sympathy from the registry that they will find a date for you. Craig Chason has developed a bit of a sport of sitting in his office and reacting with mirth and laughter when we skulk back at the end of the day with our boxes of binders, having sat there doing nothing all day. So people in the courts are doing their best, but you can only work with what you have. But I'm frankly tired of having to explain to clients again and again why their simple documents application or a summary trial application cannot be heard for months and months and months, which of course then pushes trial off more and more and more. We're talking years about getting to trial. But even when you get to a hearing, the rules and the processes of the court interfere, I find. In most jurisdictions, and Dan touched on this, absent a formal order for case management, or if the trial is expected to be over a certain number of days, you face being heard by a succession of different judges or associate judges, each one doing their best with the limited time that she's been provided, with an avalanche of more cases coming down the line. But you have to present the same case again and again and again. And different perspectives are almost always useful, but access to those different perspectives comes at the price of inefficiency and delay. And fundamentally, at the end of the day, all of this costs clients money. The reality is that a lot of those wasted costs are absorbed by lawyers themselves, firms themselves, and that may be something that should be recognized in a different forum perhaps, but the bulk of the costs hit the clients. Most clients don't have unlimited funds, so every dollar that is wasted on having someone sit in chambers waiting to be heard is one less dollar that can be spent on a substantive case. So it becomes an access to justice issue. So really, in my view, these challenges that are presented and faced by our present civil justice system fall into 4 categories. 1, inefficiency. 2, delay. 3, inconsistency. And 4, barriers to justice. And you can see where this is going, because all of those are matters on which the arbitration process is well placed to provide some assistance, even where the substantive dispute is going to end up before a trial judge at the end of the day. And I look forward to discussing more about how these 2 systems can coexist and telescope perhaps those pre-trial procedures.
Chris, did you want to speak to Alberta?
Okay, since you've answered at the high level most of the problems that I was going to discuss, I will focus a little bit about what was going on in Alberta. And of course, I was a judge there for 15 years and so have some insight as to what's going on behind the doors in terms of why civil litigation matters aren't being heard, and the problems, BC's problems are particularly acute. In Alberta, we have the same problem with respect to what we call specials, anything that's a 2-hour application or anything that's a more substantive matter can take up to 1 year, not only in the Superior Court, but also with our, what we used to call masters, or now called application judges, for other procedural matters. So what happens, of course, as you all know, then the litigation can stall, and it's terrible. So what happens behind the doors is that we will get lists. I don't know about other jurisdictions so much, but in Alberta anyways, there's lists, and if you're the supervising judge, you work with the registrar, people setting the lists, and then you have to decide. You know you have 30 judges, say in Calgary, at any one time. You look and you've got 10 criminal matters, 10 family matters with parenting concerns and custody issues, and then the civil matters are at the bottom of the list, okay? I'm sorry to tell you this, but this is the reality of how it works. So you're looking at, then you're looking at with the criminal matters, which ones are near Jordan limits, which ones are gonna get pounced or bounced on the criminal side, and the last thing the court wants is for potential rapists, etc., to walk free, so those guys will get priority. Custody family matters will get priority, and so then what gets bounced is civil matters, and it happens all the time. Within the court, there's a lot of pushback. Like, I was a civil litigator for 23 years, and this upset me, and I would say, you know, it's not just family matters and criminal matters that are important. You know, in Alberta, we have a robust commercial business world here that needs to be serviced as well. And the pushback that I would get was basically, well, they can be served privately. Okay, so that was the pushback. It's a public system. The court system's public. There's certain things that cannot be serviced privately, i.e. murder trials, or sometimes custody matters. And even the family stuff is being serviced privately quite a bit. So I liken what's happened to our system in a way to our public versus private medical system. Okay, if you wanna, you can wait in Alberta for a year, or you can fly to Toronto, ironically, and get it in a couple of months, just pay a pile of dough. Okay, so it's sort of the same in a way. We've got a public system. The funding of courts is very poor. It's not a high priority for politicians. It rarely hits the news. I saw actually today that it sort of hit the news a little bit with the talk that the Chief Justice gave. So that was interesting, but you know, it rarely hits the news. And sometimes with respect to appointments of judges and the fact that they're behind. But it really, that is only, the appointment of judges becomes a big issue all the time in the press, but that is really a very small part of the problem. The problem is much more systemic in terms of the number of unrepresented people in the courts, and everything go way longer, so everything takes way longer. And I'm talking huge. Most of you may not even recognize this. I urge you to maybe go over to your courthouse and sit around once in a while, just see the chaos. Okay, so there's that, there's the underfunding at the clerk level and all of the machines that make the system work. It's not just a lack of judges. Anyways, for all these reasons, litigation, civil litigation, gets stalled out, and it's basically more or less left the courthouse. You know, as with a normal judge in jurisdictions with general jurisdiction, you know, general jurisdictions over everything. Most judges, even with commercial backgrounds like me, would rarely be doing commercial matters, with the one exception of the commercial insolvency list. I was on the list. His name is Frank. I was on the list. So we would. I think they're well serviced. the insolvency, emergent bankruptcy matters, those are well serviced by the courts. Injunction, urgent injunction matters, those would sort of get the attention of the courts because sometimes those need to be dealt with. But otherwise, it's at the bottom of the list. So that just gives you a little insight about all of these, the reasons perhaps about why these things are happening. And it struck me that, and I know that Megan had a wonderful article about this a few years ago when I've spoken to Colin Campbell, who's doing this kind of work, this kind of help, and help not necessarily have the whole of an action arbitrated, which is of course wonderful, but having private judges basically do distinct matters within a litigation system. And it just seems to be at least what you would, if you wanted to stay in a litigation system, you could do distinct matters and try to move the litigation along. So that's sort of what we're talking about, and hopefully that gives you a little bit of insight. It's kind of depressing topic in the morning, but about what's going on behind the scenes in the courthouse.
Thanks, Chris. So that's the segue into the question I have for Jack, which is how can arbitration address the problems that Rob and Chris have been explaining to us?
Well, thanks, Dan. Can you hear me at the back all right?
Got it.
Hands up in the back row, so I guess it's okay. Well, the problem, as indicated, is that there's such delay in resolving disputes through the litigation process, and it can take many years. My own horror story was the last case that I tried, and it took 12 years. And it wasn't a big case. It was a commercial dispute about the sale of a parcel of land for a horse dealership. And it cratered at the last minute, and the vendor retained our firm to act for him in this lawsuit. So we go through the usual steps in terms of the pleadings and discoveries and retaining experts and that sort of thing. And had a mediation, which was unsuccessful. And in Alberta, you had to file a certificate of readiness. It's certifying that all steps had been taken and you were ready to have the case set down for trial. And so we sat the case down for trial years ahead. We get to the date and we get bounced because of Jordan. They give us another date. Months pass again, we get bounced again because of Jordan. Finally, we get the judge assigned and for a date in the trial some distance ahead. We're given a week. We run out of time. We need 2 more days. And the judge is not available because he's off in a murder trial in Fort McMurray or something. And so we have to wait till he's got 2 days in his schedule. And we show up, we finish the case. Then of course there's argument has to go in. That takes a while. Once all the argument's in, we wait 3 years to get a written decision, which was 12 pages, most of which was lifted out of either my brief or the other counsel's brief. I won, he appealed. Then you gotta wait for the Court of Appeal to give you a date. Go to the Court of Appeal. I won 2-1. So there was a dissent, application for leave to appeal to the Supreme Court of Canada. And my client, Dick, was a wonderful client to have, and then fortunately, he was a very wealthy guy, and it wasn't a question of can he put food on the table for his family. It was, do we drive a Porsche or an Audi or whatever. And he said, Jack, he said, I was a lot younger when this case started. And what can you say? And the bad part of it was, this is the only time in my career ever that I did a contingent fee lawsuit. Of course, you don't get paid to the end. And $1 today, or 12 years ago, I mean, there's a big difference.
But you have trouble putting food on the table at your house?
Any event, Anyway, enjoyed working with him years ago. So the problem is that this system doesn't serve the interests of justice. And not the commercial world. They want to get answers because they're moving on with their businesses. And they have to have answers. Of course, in the personal affairs, you have to have answers too. So waiting 12 years in my case, and that's by no means the longest. I think Mary was involved in a case that went a lot longer than that. Hearing, cases that have gone on 17 years and so on in Alberta, which is pretty tragic. So you have to look for means to speed up the resolution of disputes. So what's the promise of arbitration? The promise of arbitration is expedition and efficiency, get it done more quickly. And so we've got to have a different system. It's not the court system, notwithstanding the efforts of so many litigators who don't know what arbitration, they don't know how to spell arbitration. They take on matters and they want to turn it into a private litigation. And I had an arbitration here in Toronto years ago, and they incorporated the Ontario Rules of Court, which turned out to be a nightmare for us. But in any event, we got through that. But so you've got to use different approaches, and arbitration's features provide a different system for the resolution of disputes. And so I'll touch on some of those because some of them become important and helpful ways of speeding up the process and allowing people to get their disputes determined. So at there are really three different times, I guess, when you can consider arbitration. You can consider it right at the very beginning. You get into a dispute, and you know by the nature of the dispute it's going to be a 5 or 10 year deal. And during the end of my time with Bob Dixon, I had to ask myself, can I take this on knowing that I'm going to be retired or even dead before it goes to court, And I remember having that discussion with clients saying, this is going on longer than I'm going on, and I think you're going to have to get another lawyer, which they did within the firm, which was fine. But so you can make that decision right at the outset that we're going to shift over to an arbitration route. Or at some point during a litigation, if it becomes clear that you've got a problem, a year or 2 year delay getting an application heard, and the parties want to get the thing resolved, you can move that over to arbitration. And perhaps if the parties are so willing, you can continue with the arbitration through the final resolution. Or there may be just a specific issue, a case management issue, that you're going to have to wait a long time to get resolved. And in a complex case, there may be many of these arise. And if you have to wait a year each time you've got the need for a special application, it stretches out the horizon for the case. Witnesses die, interests change, people get older, they forget things, and so on. You've got all sorts of problems. Plus, you may well have a different applications judge on each one of the applications. So you're starting over with the education process. The judge has to be made to understand what the case is all about and so on. So the arbitration process, though, is a little different. The parties select the arbitrator, and you find somebody who's available. And if you call Jerry Davis and he's got a full caseload, well, Joel Richter is available. You get somebody that can take the matter on in a timely way and can commit right at the outset that, yes, I've got the time to see this through and get it resolved. So it's the selection of the arbitrator that's really important. And of course, as part of the selection process, you can get somebody that you are satisfied or you believe, you've been maybe misled, but you believe that they have the ability to deal with this in a proper way. So then you have an arbitrator in, and once an arbitrator gets involved, as we've heard from the previous panels, you have your introductory meeting and you have your first procedural conference. But the arbitrator case manages the process from there on. And you stick with that one arbitrator then through the rest of the proceeding. You're not changing horses every time and having to re-educate the applications judge. And the arbitrators then have a lot of say in the control of the process. And I know there's a great debate as to, is this the process of the parties, or is this the process of arbitration that the parties had agreed to, and should the arbitrator control that process? And that's a complex subject. Different arbitrators take different approaches. Some sort of yield to whatever the parties want, but as was pointed out, you can say to the parties, well, listen, there is another way of doing this. You don't have to have production of any document that maybe may touch on the matter as an issue in the litigation. You can use the approaches that are used in arbitration and that sort of thing. And I certainly agree with the comment about having the parties involved in the procedural conferences, because that general counsel is actually paying the bills. And the lawyer may want to do it longhand way. The general counsel was saying, boy, I got to save some money. I've got a budget that I've got to adhere to. So there's greater control over the process and such things as document production and that sort of thing. And arbitration is front-end loaded. And I think that's probably the big difference. The arbitrator goes into the hearing having read everything. And it's not a big question mark, what's this case about? And I'm sure, Chris, you can add some color there as to how bad the situation was in terms of finding out the night before that you've got a very complex commercial case and you don't know anything about it. Whereas in arbitration, Scott would have got all the materials, he's read all the briefs and the expert reports and witness statements and so on. And you can then limit your hearing, whether it's an application or it's an arbitration itself. You can limit it to cross-examination. Usually there's an opportunity for kind of a warm-up for back witnesses and maybe a brief presentation by experts, summation of the report.
Chuck, I wonder if what we should now turn to is some of the examples of court proceedings or court applications that can be handled by arbitrators to assist the parties and assist the court in getting the case moved along to trial if the parties ultimately want to stay within the judicial system, or they may choose, once they have a taste of the advantages of arbitration through the pretrial procedural steps, to move the entire case for arbitration. Chris, did you want to speak to a couple of the types of proceedings or applications that would be well suited to this?
Sure. Thanks a lot, Jack, about a review of how the arbitration process works. And one of the interesting things is what we're trying to talk about here today is about in a litigation context. We're sort of talking to people that are on our side, I hope, but what happens is the people who are running litigation matters are litigators, and a lot of them don't know about the arbitration process very well. And so one of the things that we're trying to discuss is how we can try to convince litigators that if they want to get a distinct issue dealt with, like a trial of an issue within the court, a document production issue, or even a summary judgment. We could potentially do a summary judgment thing, but pleading issues, litigation issues, like you could do, or litigation plan issues. You could do a variety of different issues that could be dealt with. You have to try to keep it simple. And I think, Megan, you have some experience there of trying to keep this application simple. And I even, my friend Lisa was speaking about this a couple of weeks ago, about you could hop in and hop out of litigation. Personally, I think litigators need to learn a lot more about what the arbitration process involves. And it, we're here at these conferences, and it's quite complex. It's very different than a litigation process. You've got all these different rules and all the rest of it. So what we're trying to talk about is something to try to keep the litigators comfortable because they're worried. We've talked to a lot of litigators about this, like why don't you hire private arbitrators for distinct issues? And I think one of the reasons is fear and lack of knowledge of how it would work. So in my view, you could try to keep it as simple as possible with a very simple outline. And I've had this, I have been retained to do simple hearings about one issue within a litigation process, and I'll just say, okay, we don't need big, long terms of procedure, the terms of appointment are quite simple, and I said, well, we get briefs, a few witness statements, you come in, we'll do a 2-hour application, virtually usually, so it's easy for them, and then I'll give you a decision within 30 or 60 days, depending on how complex it is, and boom, you can carry on with your litigation. And I've done that, and sort of, I think to steal your term, Lisa, the hop in, hop out type of help that arbitrators can give would be very useful, because then they can carry on with their litigation, get it set for trial or whatever, and yeah, maybe they'll decide, oh, maybe we'll get the whole thing done. And that's certainly happened in our Calgary market. I know that that's happened a few times, but we're talking about distinct type of things. Rob, you were going to mention a few ones that you've dealt with, so I'm going to say.
Well, I'm going to say something that will probably, Dan, get you kicked out of WCAS. Will result in me not being allowed back into British Columbia tonight, and certainly will result in Alberta not allowing me to fly over its territory, and that is this. I think there are some examples of case management and ongoing litigation being done by arbitration in the West. But my sense from talking to people in my firm and people that mentioned that it's more prevalent in this particular province. So this may be an area, and this is what I will result in my expulsion, where we may benefit from what our Ontario Eastern colleagues have learned. I will deny saying that. So take that for what it's worth. But the classic one are document disputes, and the document disputes are something where the outcome, unless it's a smoking gun issue, is unlikely to be dispositive, but it's a hurdle you have to go through on the way to trial. The rules, court rules. I don't see nothing wrong, Jack, with having a document application heard by an arbitrator in accordance with the court rules. The court rules across the country set out a really good procedure for dealing with document disputes. And it's really quite simple to put that material before an arbitrator and simply have the arbitrator make a call. But doing it before an arbitrator allows even more innovation than you can do in court. You can use the Redford schedule or the Stern schedule we use in arbitration, or don't, because we all hate that. We all hate the Redford schedule. We all hate the Stern schedule. So do something different. Use test documents to obtain test rulings. Go through categories on an iterative basis with the arbitrator on a point-counterpoint basis. The possibilities are endless. Now, it's true that sometimes that happens in court, but the reality is that it's harder to do something inventive, harder to do something innovative. When you're standing in chambers, there's 30 matters behind you, and your clock is ticking down. Now, of course, in many cases, one party is perfectly fine with delay, perfectly fine for letting things unfold, and you have to deal with that in the ordinary course. But there are cases, and we've all had them, where there's that sticking point. There's 10 documents, and at the end of it, you don't really care what the ruling is. You just need someone to make a call. And it's those document disputes that I think is the easy way in which we can use arbitration to grease the wheels of litigation and keep it along.
Well, maybe following up on that, Robin, it's the creativity that arbitration presents that litigation typically doesn't, because judges, of course, are bound by the rules of the court. And if parties will agree to an arbitrator taking on some either discrete pretrial proceedings or case management of a case through to the stage of setting it down for trial, an arbitrator can provide more creative solutions to document production issues, whether it's the rules of court or whether it's a reference process or something else. And the parties, together with the arbitrator, can determine what rules they want to apply to these arbitration proceedings within the litigation. And it may be the rules of court. In the document case, they may be perfectly comfortable with the rules of court. They just need someone other than a judge a year down the road to make a decision on certain documents. Or they may fashion their own rules. Or we may look to the arbitrator for some direction on what rules can apply. Or indeed, they could adopt some institutional rules for the steps that they have to take. And then the ability to create a process that is more effective and more efficient to resolve litigation, pretrial, procedural steps, and move a case forward is only a benefit to the parties and to access to justice. And frankly, although judges may not, in many cases, like it, relieves a lot of pressure from the court system.
No, we like it.
You like,
I
you
should
like
say
that?
I'm no longer we, I guess,
Yeah.
but anyways,
Yeah.
the judges like any help they can get, I can assure you.
Well, I also hear that the judges are jealous of the good commercial cases going to arbitration, so there's different points
Well,
of view.
they
but-
can retire from the bench. Just saying.
Sure, Jack, did you want to give it a
Yeah, in terms of, how an arbitrator can be used, I had one matter that was in litigation, and an issue arose as to whether counsel for one of the parties had a conflict. And so they decided, rather than go through the process, special application, all that sort of thing, that they'd have an arbitrator resolve that issue. So it could be done kind of right away, and that was done. And I've had another instance where the parties had a dispute about whether certain documents were privileged or not, and they did not want them seen by it was in this context, it was in a tribunal, but they wouldn't want them seen by a judge. So what do? You give that problem to an independent arbitrator, and she or he can make then decisions whether these documents are privileged or not, and if they're privileged, then they can't be seen by any of the parties in the litigation. There are lots of examples of ways in which arbitrators could be employed to deal with discrete problems that arise in the course of getting a case to trial. You don't have to wait for an application to the judge. You can hide that off and get an arbitrator to come up with a decision.
We also wanted to speak to enforcement and appeal rights. Rob, did you want to lead off on that?
Yeah, Dan, I mean, this is a potentially thorny set of issues where both parties want a decision and are willing to abide by the result. Of course, they've got no problem and everything goes along swimmingly, but that isn't always the case, even if the parties said otherwise at the beginning. So carry it through. I mean, when an arbitrator makes a final decision on the matter that has been remitted to her, that sounds like reward. And I suspect that the default, in fact, would be that the arbitrator's determination would be awarded under the relevant arbitration act, which would then train all of the appeals set aside enforcement rights applicable to any other award. And you can get into some, I think, some odd situations where in an arbitrated application in domestic litigation, the award of the arbitrator could be international, depending on the residency or location of the parties. And so it can quickly become tricky. So, and time consuming. So all of that, I think, counsels the importance of dealing with enforcement and thinking about it up front. And there's several ways that have been mooted and raised to do that. For example, the parties might agree at the outset, or even in the initial arbitration agreement, in the substantive contract, when you're talking about having arbitration deal with case management for something that otherwise might be litigated. You might agree that the arbitrator's determination will be integrated and incorporated into a consent order and simply be filed in court. Now, there's still grounds to set that aside, still grounds to treat it as a subject of an appeal, but in most jurisdictions, a consent order is a waiver of the contract and is treated accordingly. But at least then, the arbitrator's determination doesn't exist somewhat out in the ether. It becomes part of the court record itself. There might also be a possibility in certain jurisdictions, and I understand this is the case in Alberta and potentially Ontario as well, to have the judge adopt the determination as her own order. And that sounds good, but the practical problem is that you're going to be in court on an application about the application heard by the arbitrator. So it becomes contrary. I on reflection, think that the clearest way to do it would be to take the arbitrator's determination. But we're talking about something routine, like a documents application, and have it incorporated in the consent order and make it part of the formal record of litigation. But it's important because of all of the complexities that I raised earlier about what is this that the arbitrator is doing. Is it simply an award which brings into train all the other remedies under the Arbitration Act or not? To deal with enforceability at the outset and see if you can come to an agreement about how this will be enforced as part of the litigation going forward.
Right. On the last point, I was asked a few years ago, there was a document production problem, and it was a lot of privilege, which you talked about, Jack. And would I do it? I said I would. And instead of calling me an arbitrator, what I said was, why don't you get a court order? And so the court, they agreed on a court order that I would decide the issue and that they would be bound by it. So that there was no issue for appeal. I wasn't called an arbitrator. I was just directed by the court to do it. And so I set up the procedure that we followed to get the whole thing done. So that's one way you can do it, that you are up front. You know, if some party doesn't want to do this, you can't do it. It's got to be by consent. So that's what I said, and they agreed to it.
I think that's your referee example.
Yeah, under, in Alberta, there's rule 6.45, so something could be referred to, a referee, and an arbitrator could act as a referee, make the decision, and then go back, and then the judge would, and that's a procedure we're talking about, I think, Rob, which is a bit cumbersome, but quite frankly, in reality, a judge faced with, an order, unless it's kind of ridiculous, and they're just going to basically rubber stamp it, even though I hate to use that word, because we never want to be looked at rubber stamps, but that is a technical or theoretical process that we have. Or you don't do it at all. I understand maybe that when you do these kinds of things, and maybe you could speak to that, but people will agree to make these decisions outside of the litigation process, just carry on, and then we'll just carry on the process without even formalizing it in an order kind of form.
Tom O'Leary from Blue Rock Law in Calgary. I'm interested in this quite a bit because as a recovering litigator, I'll call myself now, really experiencing a lot of delay in courts, a lot of the horror stories that the panel has talked about, and see this as a way that the arbitration institution can really serve access to justice for all kinds of parties. But the flaw in the ointment, as Frank mentioned, is if parties don't want to do it, they don't have to. Christian mentioned the referee rule, which I'm not sure has ever been used for this necessarily. But are there other rules, is there other tools that the court has to strongly encourage, if not quite force, this kind of solution for efficiency?
Well, yes and no. Yes, in the sense that in Alberta, and I don't think this necessarily exists, it's certainly not in all of the provinces, we have something called the foundational rule that says the purpose of these rules is to provide a means by which claims can be fairly and justly resolved in or by a court process in a timely and cost-effective manner. And then to achieve that purpose, the parties must periodically evaluate dispute resolution process alternatives to a full trial with or without the assistance of the court. So there's some hooks within the rules, and that's one example, and Chris gave the example of the referee rules, which, as you say, Tom, to my knowledge, have certainly not been used in this way at all, for a court to be persuasive, or try to be persuasive. Maybe there are some comments about costs that might help with that persuasion. But effectively, it's a consensual process, and absent consent, I don't see that parties wish to have the case litigated in court, out of the court system into a pay-as-you-go private system. Megan, I saw you had your hand up.
Yeah, I think that's right. Forcing parties into arbitration out of a public court system doesn't really respect the foundation and the hallmark of arbitration, which is that it's a voluntary process for volunteers that come into it, who buy into it. So again, to the point on appeals, if you have true volunteers coming into a case management arbitration process, typically they will agree to a no appeal provision in their case management arbitration agreement. And you can do the consent order. That's an easy and elegant way of getting it on the record. And the consent order should also have something about costs of that interim step in it, so that the trial judge has something to go off of, at least fixing costs, even if they're awarded in the cause. So there's lots of ways that we can interact and make the trial judge's job easier to deal with what we've done outside of court. But at the outset, foundationally, you need to have the parties buying into the process. And the way we do that is we keep talking about case management arbitration, all the benefits of it, how fast it can go. It's obviously very useful for production disputes, discovery disputes, taking a lot of time off the docket of associate judges who are dealing with those and hate them, frankly, because it'll be a whole day on refusals. Nobody wants to listen to that. I will, because it's not going to be a full day for me. It'll be an hour, the way we streamline the process, right? And having cost consequences built into those interim steps within the arbitration is further discipline to the process. Another way that I just wanted to highlight that case management arbitration can be used is completely outside of the court system. Case management arbitration can be used within arbitration, particularly where you have a decision maker who's appointed for subject matter expertise, for example, who may have a supercharged schedule and low availability, who may have less training or no training in legal issues or arbitration itself. So you would want, it would be very beneficial to have a case management arbitrator readying the record for that subject matter arbitrator. So everything foundationally is there on the evidentiary record and ready for him or her to make that decision.
Can I say something, Jack? I mean, Megan, I take the point, and I agree that of course it's a process in which the parties have to agree they're going to participate. But I think there are steps that could be taken by the litigation system to make the parties want to agree, right? And you know, we talk a long time, and everyone thinks that it's a really good idea, but we don't get, except in some regions of the country, enough traction. And so I thought about, you know, what can you do to make parties want to agree, to want to consent to this? And apart from simply talking about it, there are some structural things that could be done. You know, earlier access to trial dates, for example, if the parties have had certain of their interlocutory matters arbitrated. Maybe you get a jump up on that telethon in British Columbia that I spoke earlier. Something that I think may have traction is we incentivize people with costs awards in litigation all the time. So just as though there are cost consequences to rejecting an offer to settle, perhaps there are cost consequences, meaningful ones, from rejecting an offer to arbitrate an interlocutory dispute. Of course, then we have to have meaningful cost consequences. But those are things where parties can be, may be able to be compelled to want to do something they might otherwise not to do. And I don't think we should foreclose the possibility of formally pushing for a rule on it. You know, we for many years, we wrung our hands about how could mediation be mandatory. And mediation costs money. It's not free. We're past that. And so maybe one day we will get to a point where someone could be compelled to arbitrate, even though it costs money, even though the foundation, just as in mediation, is consent and party autonomy. But I think there's some intermediate steps we can take.
You speak to that.
Other questions?
So this is actually a good segue, I think, from the last couple of comments. I'll just preface it by saying, you know, when I set out to be a full-time arbitrator, I tried to find ideas wherever I could on how to make arbitration more efficient. Most of the full-time arbitrators at that time were retired judges. And I remember talking to one retired judge and saying, you know, can you give, you know, what ideas do you have about how to make arbitration more efficient? And his answer was, well, I keep telling counsel, be more efficient, and they never are. You know? So that was not a good source of ideas. Now you turn to the bar, and the problem, you know, with lawyers, you may or may not agree with me, is reactive evaluation. You know, we are really good at finding problems for solutions, more than we're focused on finding solutions for problems. So whatever suggestion you make, or you're likely to get pushback from one side or the other. Oh, what about this? What about that? So yes, talking about it and so on is good, and we come up with good ideas. But what I really think is needed here is to have a group of people who are interested in promoting this idea, preferably from across the country, get together and put together a package of how this is normally going to work in most situations. By having a package, a pre-set package, always be varied, can always be rejected on certain circumstances, but what you do is for each point you're showing, you're anticipating and addressing the potential concerns, and you're showing what the solutions are holistically. And that may include just a set of rules that could be adopted by institutions, but it could also include recommendations for complementary legislation, which is why I say I'm building on the previous two. But I think you need a concrete package that does that. Then you roll it out to the profession. Now I think lawyers are much more apt to say, this is a thing. This is a thing. I'm not responsible for inventing it. I'm not responsible for any aspect of it that goes wrong. People have thought about it. We can opt into this. So, or in certain circumstances, the court can feel comfortable imposing it on the parties, because I think courts are more comfortable when they're referring something to an institution as opposed to an individual. So, you know, and there's no reason why the institutional rules couldn't all look the same if it's a good idea. So I have been encouraging people on an individual basis to do this who have an interest in the area, and I think more should be done than just talking about it.
Well, thank you, Bill. I think we have time for one more question. John? Oh, and Chris has a closing comment for us.
I don't want to interrupt.
So I congratulate this panel because you've raised an astonishing array of issues that are so apparent in this problem. The system has failed. It's not a matter of the system moving, it's failed, it's stalled, it's absolutely stalled. The same kind of story that Jack has talked about, I have. But what I want everybody to think about, having regard to Bill's comments, is that we are redoing the rules here in Ontario. And they are being very aggressive. I've had a minor role to play in it, very minor, for CAD. But they're going to change the whole system. And so now's the time that Bill's suggestions should be put in play before the Chief Justice of the Trial Division, who has now been ordered to make these changes to make the system work. So one of the things that I would have, if we're going to do it, is an arbitration in aid. And I would have, every case has to be from beginning to the trial date being set, only 2 years. And if you put time limits on it, you then somehow get down to something of justice where people will still be alive when the case is decided. And the other part is that everybody's going to have to find solutions. If you have an arbitration in aid, where I have just arranged one, the very senior judge, he will mediate the issues, and if the parties consent, he'll decide them. And in my view, this is exactly what's going to happen. And we have the same, just 10 years since the case started. Witnesses are now in their 80s. We got to get on with this case. It's a huge case. So time is the key. Arbitration in aid is a possibility. If you want to have something fancy, you got 2 years to get it done. That'll solve the problem quickly.
Thanks, John. Chris, did you have one you need to share?
No, don't worry.
I just saw Chris anxious to.
No, it's okay.
Okay, well, then let me just say thank you to all of you for your very helpful comments, and thank you to the panel.